Children's Online Privacy Protection Act, COPPA, a U.S. federal law designed to protect the privacy of children under the age of 13 online. COPPA requires operators of websites and online services directed to children to obtain verifiable parental consent before collecting, using, or disclosing personal information from children. Organizations must navigate the complexities of obtaining verifiable consent and implement practices to ensure they do not unlawfully collect data from children, including age verification mechanisms and clear parental notices. Health Insurance Portability and Accountability Act, HIPAA, a U.S. federal law that provides data privacy and security provisions for safeguarding medical information. HIPAA applies to covered entities and their business associates, setting standards for the protection of individuals' medical records and other personal health information. Organizations face challenges in complying with HIPAA's privacy and security rules, particularly around the use and disclosure of protected health information, ensuring adequate safeguards are in place, and understanding the nuances of HIPAA compliance in a digital age. Fair Credit Reporting Act, FCRA, a U.S. federal law that regulates the collection, dissemination, and use of consumer information, including consumer credit information. FCRA is designed to ensure the accuracy, fairness, and privacy of information in the files of consumer reporting agencies. Organizations that use consumer reports must ensure they have a permissible purpose under the FCRA, provide necessary disclosures, and comply with consumer rights provisions, such as the right to dispute inaccurate information. California Consumer Privacy Act, CCPA, a state statute intended to enhance privacy rights and consumer protection for residents of California, USA. The CCPA grants California residents new rights regarding their personal information, including the right to know, right to delete, and right to opt out of the sale of personal information. Businesses must adapt to CCPA compliance by updating their privacy policies, establishing processes to respond to consumer requests, and managing data in a way that aligns with the CCPA's requirements. General Data Protection Regulation, GDPR, applicability in the US. Although European regulation, the GDPR has extraterritorial applicability, affecting US organizations that offer goods or services to, or monitor the behavior of, individuals in the EU. US organizations must assess the scope of GDPR applicability to their operations, implement compliance measures such as appointing an EU representative, and align data protection practices with GDPR requirements, despite potential differences from US privacy laws. Electronic Communications Privacy Act, ECPA, and the Stored Communications Act, SCA, US federal laws that govern the interception and storage of electronic communications. ECPA and SCA protect against unauthorized interception of electronic communications and access to stored communications, with specific provisions for law enforcement access. Organizations must ensure compliance with requirements for the lawful interception and disclosure of electronic communications, balancing privacy considerations with legal obligations. Gramm-Leach-Bliley Act, GLBA, a U.S. federal law that requires financial institutions to explain their information sharing practices to their customers and to safeguard sensitive data. GLBA applies to companies that offer financial products or services like loans, financial or investment advice, or insurance. Financial institutions must navigate GLBA's privacy rule and safeguards rule, implementing measures to protect customer information and providing clear and concise privacy notices. Federal Trade Commission Act, FTC Act, a U.S. federal law that establishes the Federal Trade Commission, FTC, and empowers it to prevent unfair or deceptive practices in the marketplace. Under the FTC Act, the FTC has become a primary enforcer of privacy and data protection laws in the U.S., including actions against companies for privacy violations. Organizations must ensure that their practices do not mislead consumers about their privacy practices and data security measures, to avoid enforcement actions by the FTC. State data breach notification laws. U.S. states have enacted data breach notification laws that require businesses to notify individuals affected by a data breach involving personal information. These laws vary by state in terms of the definition of personal information, the timing and manner of the notification, and exemptions. Organizations must manage compliance with a patchwork of state laws, ensuring timely and compliant notifications in the event of a data breach. Biometric information privacy laws. Several U.S. states have enacted laws specifically addressing the collection, use, and storage of biometric information, such as fingerprints, facial recognition data, and iris scans. These laws, including the Illinois Biometric Information Privacy Act, BIPA, impose consent requirements and safeguards for handling biometric data. Organizations using biometric technology must navigate these legal requirements, implementing robust consent mechanisms and data protection measures for biometric information. Video Privacy Protection Act, VPPA, a U.S. federal law designed to prevent the wrongful disclosure of videotape rental or sale records. The VPPA prohibits videotape service providers from disclosing information about consumers' viewing preferences without their consent. Organizations involved in the distribution of video content must ensure that any sharing of consumer viewing history is compliant with VPPA requirements, including obtaining explicit consent and providing adequate notices. Telephone Consumer Protection Act, TCPA, a U.S. federal law that restricts telemarketing communications via telephone calls, SMS text messages, and fax. The TCPA requires businesses to obtain prior express consent from consumers before making telemarketing calls or sending texts, and it establishes the Do Not Call registry. Organizations engaging in telemarketing must navigate TCPA compliance by maintaining consent records, respecting the Do Not Call list, and implementing processes to withdraw consent. Children's Online Privacy Protection Act, COPPA, reiteration. COPPA requires websites and online services directed at children under 13 to obtain verifiable parental consent before collecting personal information. Given its significance, it's crucial for organizations to accurately verify the age of their users and secure parental consent, ensuring that children's data is collected and processed safely and in accordance with COPPA's stringent requirements. State consumer privacy laws. Following the CCPA, several U.S. states have enacted or are considering their own consumer privacy laws, such as the Virginia Consumer Data Protection Act, CDPA, and the Colorado Privacy Act, CPA. These laws introduce additional rights for consumers and obligations for businesses, including data access, correction, deletion, and portability. Organizations must keep abreast of emerging state-level privacy legislation, ensuring that data practices are flexible enough to comply with the growing and evolving regulatory landscape. US EU and US Swiss Privacy Shield frameworks that were designed to facilitate transatlantic exchanges of personal data for commercial purposes between the EU and Switzerland and the US. Following the invalidation of the Privacy Shield by the Court of Justice of the European Union, organizations must find alternative mechanisms for lawful data transfers, such as standard contractual clauses, SCCs, or binding corporate rules, BCRs, while monitoring legal developments for new transatlantic data transfer solutions. Financial privacy under the Gramm-Leach-Bliley Act, GLBA, reiteration. The GLBA's financial privacy rule requires financial institutions to provide clear disclosures about their information sharing practices and to safeguard sensitive data. This highlights the importance for financial organizations to not only comply with GLBA's initial requirements but also to continuously evaluate and strengthen their data protection measures to ensure the confidentiality and integrity of customer financial information. Drivers Privacy Protection Act, DPPA, a U.S. federal law that restricts the disclosure of personal information gathered by state departments of motor vehicles, DMVs. The DPPA protects the privacy of personal information assembled by DMVs, including individuals' names, addresses, and license numbers. Organizations that access or use drivers' information must comply with DPPA restrictions, ensuring such data is used only for permissible purposes and with appropriate safeguards. Health Information Technology for Economic and Clinical Health, HITECH, Act, an act that promotes the adoption and meaningful use of health information technology, substantially increasing the scope of privacy and security protections available under HIPAA. The HITECH Act strengthens the enforcement of HIPAA rules by introducing higher penalties for non-compliance and extending requirements to business associates of covered entities. Healthcare providers, payers, and their business associates must ensure robust security measures are in place for electronic health records and comply with enhanced HIPAA and HITECH obligations. CAN-SPAM Act, a U.S. federal law that sets rules for commercial email, establishes requirements for commercial messages, gives recipients the right to have emails stopped from being sent to them, and spells out tough penalties for violations. Organizations that use email for marketing purposes must ensure their messages are compliant with CAN-SPAM requirements, such as providing a clear mechanism for opting out of future emails and accurately identifying the sender in the email content. State biometric privacy laws reiteration. With the growing use of biometric data, compliance with state biometric privacy laws like Illinois BIPA becomes increasingly critical. Organizations collecting or using biometric information must implement practices that comply with consent, notice, and data protection requirements of these laws, preparing for potential expansion of biometric legislation to other states and adapting to the specific legal landscape around biometric data protection.